Welcome to the Cello Law Weekly Webinar. Today is July 7th, 2021, and I want to thank all those who are joining us today. Let's give them a few minutes to get started. And before we get started, I want to give a shout out to my brother, my baby brother, it's his birthday today. So I want to wish Mutti Golakorta a very happy birthday today, and hope he's celebrating and having a great time. So have you been wondering what all the buzz is about the processing times, the unused numbers, how can they affect the visa bulletin? Well, you have joined the perfect YouTube webinar today, because we're going to debunk all of this and put it to you in a way that you can understand why this is an issue and how actually, what does this all mean? And so we're going to did a lot of number crunching, and we're going to go over that in just a few minutes. So I hope everyone is doing fine. I hope you had a safe and fruitful July 4th. And giving folks just a few seconds to join, and then we'll get started. So where did this all begin? The idea of, the visa bulletin, the numbers, and the allocation. So in 1990, Congress enacted the numerical limits for the different categories. So intending that all the numbers that are allocated should be utilized. And as we know, it's 140,000 for employment-based, and it's 480,000 for family-based, minus the, the immediate relatives that come in to play. So the immediate relatives, which are family members who are spouse, children under 21, and you can't see the video? Can you see it now? Can everyone see the video now? Okay, good. Video is working. Fantastic. So do I need to start from the beginning, or were you able to see the video before? Could you hear me at least? Good, good, good. Okay, great. So like I said, in 1990, Congress established the numerical limits. And you have the employment-based, and with the family-based, what they did was they said that they would subtract the numerical limit of immediate relatives, because immediate relatives are not subject to the numerical limits. And who are immediate relatives? Immediate relatives are the spouses of US citizens, the sons and daughters under the age of 21, and parents of US citizens. These individuals were not counted, so they would be subtracted from the whole. And then what they would do is add on to that the number of employment-based that weren't used. And but they for the family-based, the floor of that could be no less than 226,000. So I know it sounds kind of crazy, but the problem was not that. The problem was how the process was structured. So the number of family, I'm going to have to look at some sheets today because I've got numbers and I can't remember all of them off the top of my head. So the numbers of immediate relatives admitted have been high enough to keep family base at its annual cap at a minimum of 226,000 for the past 20 years. That means that no employment-based green cards have truly been allocated to roll over, and don't roll over when they're lost. And the current employment-based green card backlog are more than 900,000 cases. So Congress should basically fix the formula, because what happens is they subtract the numbers of the immediate relatives before the family base gets in, and I'm going to show you how that's done. So Congress has recaptured numbers previously. They did that in the American Competitiveness Act, where they did a one-time recapture of 130,000 some odd green cards that went unused from 1999 to 2000. and Real ID recaptured 50,000 green cards, but these were made only available to nurses. So since the last recapture effort in 2005, 15,000 green cards have gone unused by any employment-based or family-based are effectively lost. And if extended back to 1992, the green card recapture could provide more than 220,000 previously unused green cards for applicants stuck in the backlogs. Let me show you what I mean. Let me give you an example. Okay, if you can see this, in 2006, the family-based limit was calculated by close this and close this. I don't know. Okay. So 2006, the family-based limit was calculated by subtracting 436, 115,000 of the number, and the number of immediate relatives from the base of the 480,000. Because remember, through the years, immediate relatives has been increasing, leaving the initial total of 43,885 for the family-based. Then it was increased because there was 10,288 of the unused employment numbers that carried from 2005 for the new total of 54,173. But because this is below the mandatory floor of the numerical limit defaulted to 226,000, the 10,288 unused employment green cards had no impact on the annual limit and were never used. So it's the 226 floor that, and the way it's being calculated, that it's crazy that it is causing that issue of a number of unused employment-based green cards. And I believe the current total of unused green cards is, because I've got the historical data of unused. The tables I've been seeing online have been references to the statistical backlogs, which date back, I think the earliest was 2011. And this one is giving me numbers up till 2019. So it was 221,810 that are basically unused and could be recaptured. Now, how does one go about doing this? Well, the executive branch has the ability to do it, but Congress should, because that was the intention of the act, to make sure that none of these numbers go unused, and they need to correct what seems to be a very faulty formula in this process. And to make things worse is the processing time, right? Because remember, the USCIS fiscal year is from October 1st from October to October. So their first quarter is from October, November, January, October, November, December, January is the first quarter. And so to take a look at what the processing time has been, I am going to share another one with you. So if you can see this, let me see if I can make it so we can scroll down a bit. I hope everyone can see this. So the pertinent numbers I want to show you is, remember last year, the fourth quarter of 2020 was right before the the visa bulletin numbers advanced. They advanced in October of last year, October 2020, which would be fiscal year of the first quarter 2021. So if we want to see how we were progressing, as you can see, 26,000 in 2019. That was the fourth quarter of 2019. I didn't have the first quarter of 2020, but the second quarter is 20,000. Third quarter of 2020 was 12,301, which is about right now of last year, were received. And fourth quarter of 2020, which is from, I think, July to October, there was an additional 20,086 petitions received. But look at the numbers that were approved and look at the numbers total processed for those years. On average, you had, I think, 16,000, then there was 20,000, 14,000. Look at the surge in the fourth quarter of 2020, where they processed 50,000 in one quarter adjustments, clearing the pending backlog from 148,397 to 118,719. Wow. What happened after the fourth quarter, or what happened before the fourth quarter? But more specifically, what happened after the fourth quarter? Well, I would say 2020, early 2020, we're all dealing with the pandemic and offices were closed. Things started going back to some normalcy in the fourth quarter. After the fourth quarter, the USCIS started having a lot of financial issues because there were less petitions filed that year. On average, for all applications, the USCIS receives anywhere from 7.6 million odd applications and petitions per year. So last year there was a decrease in that, but more importantly, the offices started opening back up. After the fourth quarter, when USCIS was having some financial difficulties, they laid off all their, they threatened that they would have to lay off their workers, but instead they laid off all their contract workers. All their 1099s were laid off. And I haven't heard that they were rehired yet. So what happens? Boom, in the first quarter, that's October, November, December, and January, USCIS receives 87,267 applications, and they processed about 28,000 in the first quarter, 817. In the second quarter, they received 117,584, but they could only process 19,506. Now, a lot of these contract workers, were actually working in the lockbox, opening up the files and everything else. So one of the assumptions I'm going to make, and until I find out the contractors were rehired, is that because the surge in applications, that they didn't have enough, it really impacted their resources to process. And so they were only able to process 19,000. But let's hope they can, do what the previous administration did and kind of bump up the applications for processing. Now, if you look at average processing times, I think the Nebraska Service Center is doing anywhere from an 11.5 to 19.5 months. Texas is 25 to 30 months in terms of processing. And then, of course, you have the individual centers. And here's the report. You can see how small the numbers are, so it's so difficult to read them. But it has this by individual office numbers, and we're going to share this on our Telegram group. So if you haven't joined our Telegram group, please do. So you can join this, so you can get this data too. We'll be posting some of this data to the Telegram group today, so that they are able to have the data for themselves, and at least have the current data for this year. And so there's a you have to understand that there is a interplay between the, USCIS processing time. And if you remember, because remember we talked about how this processing time works with the USCIS. And so there is a kind of relationship between how the overseas offices are processing, how the USCIS is processing, and how the visa bulletin moves, right? So what we want to do is make sure that at least for a number of these processes, that we are able to see how it works and how it interplays. So, for example, the consulates are still working not at a maximum capacity. So they are processing, okay, get ready for this. They are processing less than 60% of what they average process. And so therefore, and when I looked at the DOL totals, a lot of them had to do with, employment base was not that much. Most of the processing had to do with the USC. I mean, most of the employment base is processed here in the United States, vast majority. Because a lot of it's family-based. So we're going to come back to that same problem, that 226,000 base, even if they're not used, that's the minimum they're going to use. So a lot of those numbers that could have rolled over are not going to be rolled over. In addition, you've got previous years where the unused numbers for employment-based were not able to be adequately added on, because if the base is under 226,000, those numbers are lost. So A, we've got processing time issues with how the USCIS is processing. B, we've got this whole thing of the unallocated numbers that Congress specifically said should be allocated. So what we're going to do is we're putting together some information. As I told you, I'm part of API 100, and they do a lot of great things to kind of advance issues and raise it to the attention of the administration and Congress. And I am going to, that's why I wanted to do an in-depth dive into this. So I'm putting together a report to present to them some of my key recommendations. Number one, that if Congress doesn't act, that the president through executive order allocate the unused numbers, because it's already been congressionally mandated. So, you really don't have to get Congress's permission again, because it's provided for in the statute. Second, that they allow the dates to freeze for CSPA purpose for dates of filing. And that way, waiting for the priority date, because remember the priority date is impacted by the processing, waiting for the priority date to be current won't hinder some children who are going to be turning 21, who are in the dates of filing process, to age out. Number three, as recently the USCIS director was conferred, and she had Senate hearings. And one of the things that she had stated that was very important to her was decreasing the backlogs and streamlining the process. And she thinks she can do a lot of that with technology and a number of other things. But that takes time, and we are running out of time. So what I suggest to them is, if they are in a financial crunch, they did receive some money, the USCIS did, from the relief bill. So they have that money, and then they could add a premium processing fee to adjustment of status applications so that they can hire more people to process. that's what we need, is we need boots on the ground, we need hands, we need folks to process. So that's what we're going to be doing. And so if stay tuned, and I'll let you know what the progress is on that, and what kind of ground we're getting. That's the same thing we're going to suggest to Congresswoman Loughran's office, who supported 2 bills. But it doesn't seem like anything is getting passed with this current Congress. So we're going to suggest the same thing to her office as well, and bring the attention of how this calculation really is screwing up and having us lose a number of unused employment-based visas that could be allocated. So I know that was a lot of information. We're going to be posting some of this so it's easier to understand, and we're going to be putting some of the resources on our Telegram group. If you haven't joined, please join our Telegram group. Kara, I was trying to look for the QR code, and for the life of me, I couldn't find it. So, if you haven't joined our Telegram group, please do. And that way you will have access to, the information that we're going to be posting on there about all these things, because it's important that all of you know and understand, the issues relating to what the visa allocation is going to be, and precisely, more importantly, how this affects your process and what are some things you should be doing. I've told everyone on our web chats that if you haven't filed if you've got an EB2 and you don't have an EB3, then file an I-140 for your EB3. If you've got an EB3 and you don't have an EB2, file for that to make sure that you have that. But it's just important that all of you make sure that you're doing everything you can to avail yourself of, all the things that could impact your immigration. And on our Facebook on our Telegram group, we will also be having a live video chat where I can answer questions. And I'm thinking about doing that tomorrow, depending upon the availability of the folks there. So that's another reason why you should join our Telegram group, to make sure that you can be part of the chats tomorrow. If your question doesn't get answered today, we will make sure that you get some priority if you join our Telegram group to get the benefit of that. So let's see if I can open that. Okay. I'm trying to open up the QR code, but if I cannot, then Kara will post in the group. And so you will be able to join by that link. And, please like us on Facebook and other social media platforms. We post different things on different social media platforms for different reasons. And so please join us for that. And if you haven't checked out our YouTube videos, I'm sure in a number of these answers, I'm going to say, hey, you should join our YouTube video. You can see that answer on there. Please join the, subscribe to our YouTube channel. And that way you can avail yourself of all the resources that we have. We talk about perm applications, how to do a successful perm. We have, I'm going to finish mine on roving employees today. It talks about the working within the same MSA or within commutable distance. we have one on, the I-140 downgrade. What are some issues that are related to that? So join, subscribe to our YouTube channel so you can get notified every time we post something up. So now let's get started with, I guess, your most favorite part of the program, which is the Q&A. And shortly, our monitor, Shaker Cello, will join us, and we can go ahead and get started with the questions. Hello, Shaker, how are you?
Hello. Hi, Lakshmi, how are you? Good afternoon, everybody. Nice to see a long list of participants. Glad you are doing well, and I hope you had a good July 4th and was safe and sound and healthy. So let's get on with our Q&A. Again, just to set the stage, like I normally say every time, you please put your questions in the Q&A, and any clarifications to your question, when the attorney is asking, you can, put that in the chat. So it's just easy for me to look at it and relay to her. All right, let's go to the first question from AA. AA is anonymous attendee. That's my abbreviation. So my EB2 to EB3 downgrade, I-485 transferred from NBC to Texas, and I-140 approved. Last week transferred back to NBC and got notice from USCIS stating that case initial review completed and standard process transferred to NBC. My final action is current since March. My dependent applications are still at Texas. Please share your thoughts.
Yeah, I wouldn't worry too much. It takes about 6 weeks for a file to go from the office to the NVC. So they will make sure that your dependents are connected. I know that NVC was having some issues in terms of communication because of low staff, but I think they've gotten back to normal processing. You can try emailing them and seeing whether emailing them would help prompt them to join the files. NVC shortly will be sending you information that you will to further your processing. So, I think communicating that with them via email would help ensure that all of those are joined.
All right. Next question is from Banu Chaudhary. I hope I'm saying it correctly. Hello, good afternoon. My priority dates are current and I am CSPA covered. If I do adjustment of status, when my age freezes? Thanks.
What was the end part? He's CSPA.
If I do adjustment of status, when will my age freeze? Thanks.
Okay, yeah. So remember, CSPA age is the age the I-140 was processing. If the adjustment was filed for dates of filing, it doesn't freeze the CSPA age. If it was filed for final action dates, it does freeze the CSPA age. So if your adjustment is within the final action dates, then your CSPA age is frozen, even if it subsequently retrogresses.
All right. The next one is from another AA. Hi, Lakshmi Garu. Thank you so much. I am in EB2 with priority date September 2011, downgraded to EB3 in December 2020. Current in EB3 now, and hope will be current in next bulletin in EB2. My question is it possible to apply one more I-485 under EB2 because I need green card ASAP due to some personal reasons?
Yeah, if you downgraded by filing a new petition, that means you've got your EB2 approval notice and your EB3 approval notice. That's what I'm going to assume because you want to file a new adjustment. You don't need to file a new adjustment. What you need to do is interfile. And that's simply telling your attorney, if you've got an attorney, to send a notice to the USCIS with your I-140 EB2 approval notice, referencing the current adjustment number, the receipt number, and saying, please use this I-140 for processing the I-485. So you don't need to really file a new adjustment. Can't hear you. Can't hear you.
Okay. Next one is from another anonymous attendee. Thanks a lot, by heart. I guess the question is probably next one. Can my old employer file AOS if my priority date become current without joining them back, or is it mandatory to be with old employer to get AOS filed?
You don't have to be with the, you don't have to currently be employed by the previous employer to get filed. You have to have the present intent to work for that employer. And I told a number of people of this in October. What does that mean? That means you have to at least intend, after the green card is approved, to work for that employer. Remember, there's also AC-21. So once the I-140 is approved, once the 45 is pending for 485 days, pending for 180 days, you can change employers. So you can change your intent later on, but you have to have the present intent now. And you want to have documentation of that, like, looking at some email communication or something to show that you do have that present intent. The other thing I would request that you do is you may want to look at our things to consider when you are thinking of working with your old employer. We have a YouTube video, and if you look at that YouTube video that my team hopefully will put up in the chats, then that'll tell you what are some of the other things you should be looking at, because you still want to make sure that the employer has the ability to pay. Anytime you file an I-140, you have to demonstrate ability to pay from the time the perm was filed until you file the I-140. Really, it's until you get your green card, but effectively, it's until you file your I-140. Now, one of the main ways in which employers demonstrate that is if they're currently paying the employee the salary that's stated on the perm, on the prevailing wage. Then you prove ability to pay. But if you haven't been working for that employer, then what you're left with is using their tax returns and showing their net income or their net current assets. So take a look at that YouTube video, and it goes through the analysis really clearly.
All right. You probably hear a noise. There is a power fluctuation in the office that just happened. So I think one of my surge protector is beeping. So that's why I'm muting after I give the question.
We don't hear it.
So that's good, but just wanted to let you know the reason I'm drifting, because I'm trying to see what this noise is. And I see a question on the chat, and again, please don't put your question on the chat. Because the question, and I'll take it in the order it is received. Next one is from an anonymous attendee. When the priority date will become current for June 2017, EB3, EB2 for final action date?
June 17 is what they said.
June 2017.
Yeah, so I think we should be getting the third quarter report shortly. And that'll give us a good sense of how they're processing in the third quarter. Remember last year, in the fourth quarter, the USCIS just surged in terms of processing. We now have a USCIS director. And so I think that we should see some advancing, and that will give us a better indication, especially because we know that a lot of the consulates are still not operating at full speed. Based on how Charles Oppenheim said that they do the calculations, we can come up with some guesstimations as to how it's going to process. And if you want to know how what Charles said about processing, how they come up with the visa bulletin numbers, check out our YouTube video, and that'll basically tell you how they go through and what they look at when they're trying to assess visa allocation movement.
Next question from Mother AA. Interfiling the medicals for pending I-485, is it recommended to avoid RFE? My priority date is March 2014.
Yes, I do recommend that. I don't know why people are waiting for the RFE. If you have your medicals, remember they're only good for a certain time period, I think 60 days. So if you have your medicals, go ahead and you've got the receipt notice, go ahead and interfile. When you do that, you want to make sure that you put a cover letter and say, this is the medicals, reference your adjustment receipt number, your full name as it is in your passport, and maybe even your passport number and date of birth. Put all that in the front and say, here are the medicals for me and my dependents, and then send it by a courier that you can track, like a FedEx or UPS. And I would, even on the envelope, put your receipt number so that they, make sure that they match it up to the file.
Okay. This next question is from YouTube, one of the YouTube viewers. What is the prediction for family category F3?
Yeah, well, for family-based categories, I would say that, we haven't seen the movement, surprisingly, that we thought we would, given the lack of processing. So it's a question mark for me as to why we're not seeing, because remember, it's because of the family-based unused numbers that, okay, there we go. Kara had just put up the link about what Charles has said. So we should probably be seeing some rapid movement in that shortly.
All right. The next question is another one from YouTube. What can we do to push USCIS to not waste available GC numbers?
Yeah, so the USCIS can't do anything. What we have to do is, you can push Congress, but I think the better bet, it's in the regulations. So Congress needs to fix the allocation, the 226,000 base. But, the president could say, Congress has spoken that all the numbers need to be allocated. And I think they should do it by executive order and say, this is how we're going to allocate it. It's already in the regs. And that's why it is, because the president can't legislate. The USCIS is an office, is part of the executive office. So you've got executive, judiciary, and then you've got the legislator. The legislator is the body solely responsible through the separation of powers for enacting new regulations. So to fix the existing problem with the way things are allocated, that's what the legislature has to do. And that would be the better fix. So I think sending letters, having your friends who are US citizens in jurisdictions where there are strong Republican where there are Republican congressional officers, congressmen and senators, is the best way. The Democrats are on board with this, but you've got to make sure that, and you can do that by finding out in your jurisdiction, is there an Indian or a UK national that is now a citizen, somebody within your community, if you will, that's donated a lot of money to this Republican Party. If they have, and all that information is online, contact them. Tell them, what your problem is and what you've been going through. Have them reach the congressman on your behalf. And I think we can make some traction if we do that. if you're not a US citizen and even if you're a permanent resident, really, they're not going to, your voice won't be as impactful, even though you could be a future citizen, as the people that are already there that are voting. So leverage your contact pool and try to do it that way.
All right, next question is the one that was also on chat. It's from Omoyeni Salawu. I hope I pronounced it correctly. My EB-5 visa interview is on the 19th. What do I do? The program hasn't been reauthorized yet.
Yes. So they're probably, I'm pretty sure what they're going to do is, because they're holding a lot of the applications now in abeyance because it hasn't been reauthorized. July 17th, the USCIS is supposed to be back. I mean, sorry, Congress is supposed to be back. So let's hope that there will be some sort of reauthorization bill that's instituted then.
Okay. Next question is from Karthik Mehta. Is it safe to downgrade from EB2 to EB3 now, given 1.5 years wait for EB3 I-140 to be usable for filing dates from current EB2 approved I-140?
Yes.
That is October 2022 for I-140 to be usable. What are the risks?
Karthik, there's no risk. You can file another, if you file, since you filed a, you have an existing I-140 EB2, you just would file a new EB3 application. You can't do it in premium because you don't have the perm, but you can do it in regular processing and wait maybe for about 6 months or so and then try to upgrade to perm. But there's no risk in doing that. It won't hurt your I-140.
Well, he says, I am changing employer as current employer is not allowing EB3 downgrade from current EB2.
Okay.
Same, Karthik.
Yeah, so if you do that, then maybe, you can port to the new employer with your current I-140. The new employer cannot file an EB3 I-140 for you. Only the current employer can. And find out why your employer is not willing to do that. I'm happy to talk to him. It may be that, especially with 1.5 years away, it's not like you're gonna be leaving, and you could actually leave him right now. If you file a new I-140, this is how you can tell him you're eligible for portability right now. But if you file a new I-140 for EB3, right, the clock for AC-21 starts all over again. So you have to wait for this I-140 to be approved. It can't be approved in premium. You got to file regular, at least initially. And then you have to wait another 180 days if you're going to use this I-140 for your AOS subsequently. So, it may be in his benefit for you to use that as a leverage.
Next question is from YouTube. Any idea how attorneys check perm status? Do they get an email from the agency, or do attorneys have to log on to the portal to check status?
We get emails directly when there is an action on the perm. And we're usually alerted through DOL that it's been certified before we actually get the certification.
All right, next question. Next, just a comment from an AA. Thank you for your brief answer on AOS with old employer. We'll check the YouTube link.
Yes, because you want to make sure the ability to pay issue is taken care of. And for all of you on YouTube live, hello, thank you for joining. And we've got a lot of great resources. So since you're joining us on YouTube, check out our YouTube channel. And I hope you subscribe. But thank you again for joining and asking questions. We love this.
Next question from other AA. Hello, thank you for your valuable information. My case is still with NBC, even though the date is current from past few months. Does my case has to be transferred to FO to work on it for further processing?
Field office is FO. Yes, and so what you may want to do is kind of nudge the NVC. You can send them an email. Nudging them sometimes gets them moving. So, and I have the statistics of how many cases are currently with the NVC, but I can't remember, but we will post that. I will post the NVC, how many cases are at the NVC in our Telegram group, so make sure you join.
Next question from Prashant Adeli. My current downgrade process and I-485 is done with Chalala form. Recently, we upgraded the premium processing for I-140. It's approved. My priority date is October 2012. What's the next step? We didn't send the medicals at the time of filing.
Since the I-140 is already approved, I would say go ahead and get your medicals done, and we can just use a receipt notice to interfile it. So there's no issue.
All right. Another AA question. I-485 adjudication from NBC Texas Service Center. Which service center is best for quick adjudication? I-485 transfer from NBC Texas, NBC, is it normal?
Yeah. Did you say it went from Nebraska to Texas or Texas to Nebraska?
NBC Texas.
No, NBC is Nebraska. I mean, NSC is, well, the Nebraska Service Center. TSC is a Texas Service Center.
I-485 transfer from NBC to Texas and again back to NBC. They put NBC. Is it normal? National Benefits Center, it says.
Oh, NBC. Okay, I was thinking the Texas Service Center. No, I have seen that there is sometimes some problems with NBC and the service centers kind of communicating and having issues. So sometimes they send them back thinking that the date's not current. And then Texas says, no, the date's current, and it sends it back. So that's probably, or it's getting ready to be current. So that's probably what it is. So I would, again, check with the NBC to see where, where it is, and if you can make sure that it's getting processed as it should.
All right, another question from an AA. Can ex-employer file 485 while my new employer perm petition is under process with USCIS?
Yes, yes.
Also, can new employer file 485 once the perm is approved if priority dates are still current, or wait for 180 days and file 485J with new employer?
Yeah, you can do either. And I would, why close yourself off on an option? You can have many roads lead to Rome. So having one does not necessarily negate the other. Now, if you want to continue with the I-485 with your old employer, remember, again, you have to have the present intent to work for the employer after your green card is approved. And so as long as you have the present intent, then you can do that.
Another one from an AA. What is your best guess for priority dates in EB2 and 3 movement in October 2021 visa bulletin?
Well, I'll give you those. I know everyone keeps asking me that. That's why I am trying to figure out with all these calculations where we're going to be. I'm waiting for the third quarter processing report. We've got first quarter and second quarter. Third quarter is probably going to tell me the information, given that we know that the consulates are processing 60% less than they usually process. So stay tuned. That's why you gotta join these webinars every week. You never know when we'll have those predictions.
The next question also is kind of related to my PD is July 2015. What are the chances of EB2 or EB3 to be current this October?
Which year is it? PD is
July 2015.
2015. Yeah. I would say, they're going to be moving in the rate that they're moving now. EB2 has not advanced as much as EB3. And so we'll have to see how that effectively plays out. And so once we have an idea of how that is processing, then we'll know better how it's going to advance. Because remember, Charlie stated that, initially it's going to be they're letting EB3 advance more rapidly because EB3 has had more unused than EB2. But if that starts getting processed, then we may see EB2 advancing as well. So again, stay tuned. If you want to, we'll have some predictions shortly, the next couple of webinars.
Well, I think that's the answer to the next question from YouTube. It's any predictions for EB2 in fiscal year 2022? So I guess.
Hi, YouTube. Thanks for joining. And like I said, we're looking at the numbers, and we need the third quarter numbers to get a better sense of what the processing time would be and how that is going to affect the visa bulletin. So thank you for joining, and stay tuned, and hope to see you all again in some of our other webinars.
Next question from an AA. I'm an EB2 priority date of 2014. Should I wait for it to get current? My employer says EB2 may move faster. Please give your expert advice. What should I do? My employer says downgrade is not advisable. If it gets refused, I will lose my current EB2 I-140.
No, that's not true. You can file a new I-140 for EB3, preserving your EB2, and it won't have any risk. I don't know why employers are so scared to do this, especially if you're currently working for the employer. That means ability to pay issue is you're already getting the salary, at least close to the salary that's stated on the perm. So that there should be no risk. If you'd like, we can send you some materials on this. I'd be happy to talk to your employer. Email us at info@chalalaw.com.
Next question from another AA. Hi, Lakshmi Garu, thank you. I have filed 485 through previous employer, worked for them for 9 years. I got my EAD and date current. Can I file AC-21 without working for them? Would that be possible?
As long as you had the present intent at the time you filed, you can change your mind later on. I-140 is approved. I-485 has been pending for 180 days, and you're working for same or similar employment. Once you do that, if those 3 criteria are met, you can do that and just file an I-485J.
All right, how much time do you have?
Till 1 o'clock.
1 o'clock. So 3 more questions. So that's all we can take today. And if we couldn't answer your question, of course, I don't see any more, but I'll take the last question from Srini Rao, and anything after that, appreciate if you can just send an email to info@chalalaw. Be glad to.
Right, and join our Telegram group, because we're going to be most likely tomorrow evening, assuming my Telegram folks are able to join. We're going to send them a poll shortly. We're going to be doing a video live chat answering questions through the Telegram group. And we're also going to be posting a lot of these resources there. So.
All right, next question is from YouTube. Pretty similar to any predictions for EB3. My previous employer priority date is January 2017. My new EB3 perm was submitted in February 2021. When can we expect approval?
2021 is going to take a while. 2017 is, well, you've got that priority date. So even you filed in 2021, it would be with the 2017 priority date. Because once you have a priority date, it is secured even for your subsequent filing. So I hope you were able to do that. If you have one, and I tell everyone this, if you've got one in EB2, file an EB3. If you've got an EB3, file an EB2. It does not hurt you. It will not impact you. You can file a new petition. Don't downgrade by doing an amended, file a new petition, and then you'll have the benefit of both. And so whatever category moves faster, you will be able to leverage that.
Next question is from an AA. My daughter, I-485, filed in March in EB2 to EB3 downgrade scenario and I-140 approved. Waiting for biometrics. Is there any chance to reuse from earlier H4F1 biometrics?
They have been doing that. We've been seeing that they're using previously used biometrics. So, but it's not been applied consistently. So I would kind of wait and see. Otherwise, we've got a YouTube video on how you can contact the USCIS. Emma is not the only person. There's a lot more ways and methodologies, what information you have, what you should be doing. So please check that out.
Last question for this afternoon from Srini Rao. Can we assume that if I-485 adjudication happens quickly, then no more date advancement in coming months?
That's not necessarily true. That's one of the factors, not all of the factors. It's the consular processing, you know, how it's actually good if they process it quickly, because I think according to what the DOS had said is if it gets too backlogged is when it starts slowing down. But there's so many visas available that would not curb the advancement.
There's two questions from YouTube, and we'll just take that because I think we are just new to YouTube. But if there's any other question we didn't answer, please do send an email. This will be the last two questions since we have one more minute. First question on YouTube: do you recommend spouse to file another 485 as primary when she already has I-485 as derivative?
Sure. You know, you can have two. Everyone, I know that there was a, and we covered it in one of our earlier YouTube videos, so check that out when we talk about having two adjustments at one time. You cannot adjust on two at one time, which means the adjudicator is going to see, oh, they've got two different adjustments pending. They're going to ask you which one do you want to choose, but you're not going to get denied. So you can have two pending. So yes, I would go ahead and have your wife go ahead and file for an adjustment under hers as well.
All right, the last question, absolutely positively the last. You know, I don't know if FedEx has this tagline. They used to have the tagline, absolutely positively the best or the fastest or something. Anyway, YouTube, last question today. Receipt notice delays, filed I-140 June 20th, 2021. That's
right.
it.
So hello, YouTube. This is what you can do. If it was your check, or if it was your attorney's check or your employer's check that was used to file the I-140, when that check gets cleared, on the back of the check, they will have your receipt number. Now, that's not a receipt notice, but it will give you some sense of comfort what your receipt number is. So, you know, that would be one way to go about checking out to see what the processing is. So check out that tip. And Kara, if you can put up our Telegram link again so folks can see it. I'm sorry I couldn't get the QR links, especially for those people who are watching on YouTube, because it would be so easy. You could just do this and you could join, but I will have that next time. So
that's about all for this afternoon.
Right. I want to thank all my team for all the work that they have done in putting all of this together. For those of you who joined on YouTube, thank you so much for joining and taking out your time. For my other folks, thank you for joining every week. Shaker, thank you for all your assistance in the Q&A and moderating this.
Thank you for the opportunity. Always excited.
And we will keep you, we will always keep advocating for you, and we will keep you updated on how those advocating efforts are going. so that you can reach your immigration journey. Hope to see you next week. This is Lakshmi Chawla, Shaker Chawla.
Have a good week. See
Thank
later.
you and bye.
Bye. Bye, Lakshmi.